This is deja vu all over again. This is Civil Discourse Now. My name's Mark Small. I'm co-host with Paul Ogden. Paul?
Mark. Good afternoon.
Good afternoon to you, too. We are coming to you live from Indianapolis, Indiana on May 24th, 2012.
This March 24th. You said May, I believe.
I just go ahead in time. But I'm a progressive thinker. It's March 24th, 2012. This is Civil Discourse Now. Paul, tell the audience what the show is about.
Well, the show is Civil Discourse Now. It's where we try to have a civil discussion about the local, state, national, international issues. It's where we try to not talk over one another, try to have a good intellectual discussion of the issues with individuals who are knowledgeable about the issues.
That's true. We have two excellent guests today. To my immediate left is Matt Stone, who's a local blogger. He was a candidate for City County Council for the Libertarian Party last fall here in Indianapolis. We're coming to you from Indianapolis, Indiana. Matt, you've got a blog, don't you?
Yeah, I blog at indiestudent.blogspot.com. Also contribute to indiepolitics.org, covering the council meetings. Hopefully I'll get to cover another smoking ban introduction this coming April.
And hopefully cigars will still be exempt in cigar bars. Also, our other guest today is Gary Welsh, who blogs on Advance Indiana. Gary, welcome here. We're just going to discuss today residential requirements for voting, and that's kind of like a pretty broad subject. But here in Indianapolis, and in case you're watching from the International Space Station or Antarctica, and that's possible on the internet, we've had a controversy here in Indianapolis in the last couple of weeks, in particular, over residency requirements for the candidacy of Richard Lugar, who's a United States Senator from Indiana. He first was elected in '76, has served in that office since 1977. And Gary, you were involved in some of the administrative law procedures of that.
That's correct.
And you're an attorney here also.
I am.
And before we go any further, Paul, do you have a disclaimer you want to state?
Oh, well, I am a candidate for Marion County Superior Court judge. In the process of doing that, there are certain rules that apply to judicial candidates, which surprisingly are different from the ones that apply to judges. The ones that apply to judicial candidates kind of actually encourage you to go out and speak out on issues, but you can't make pledges or promises regarding how you would decide certain issues should you be elected.
Can't even promise you decide them fairly or even-handedly.
I might be able to get away with saying that, yes.
And we have our audience here today. And we're going to discuss the requirements. Gary, there's some history to this, but there are specific statutes and provisions in the Constitution as to residence requirements for federal office and for federal voting. Can you give us a little background?
Well, there are two standards that apply depending upon whether you're running as a candidate or versus whether you're trying to register to vote in a precinct within the state. In the case that is a big issue right now in Senator Lugar's case, he's a candidate for re-election to the U.S. Senate. And the Constitution alone sets out the qualifications for a candidate to be a U.S. Senator. And there are three qualifications. You have to be a U.S. citizen, at least 30 years of age, and be an inhabitant of the state that you represent. And the inhabitancy is triggered at the time of your election. So at a general election, a candidate for federal office needs to be an inhabitant of their state. That's why it's possible for a Hillary Clinton from Arkansas to run for New York, run for the Senate in New York, or a Robert Kennedy from Massachusetts to run for the Senate in New York. They only had to establish that they were an inhabitant of the state in which they were seeking election at the time of their actual election, which is the November election.
And who determines those qualifications?
Well, the final judge of the qualifications is each body of the Congress, which the Senate is the final judge of its members' qualifications, and the House of Representatives is the final judge of its qualifications.
Are they the final judge, or are they the exclusive judge? Are they
They are the final judge.
Okay.
Certainly states, if someone that's 25 years old files to run as a U.S. Senator in Indiana, the State Election Commission on a challenge could remove that person from the ballot because they obviously don't meet the age requirement to be a U.S. citizen. Or if you're a permanent resident and not a U.S. citizen and you're running for the office, they could deem you ineligible. Interestingly, in order to be a candidate for federal office, you don't have to be a registered voter of the state in which you are seeking office. And that's kind of a mistake that a lot of people make. They assume that you have to be a registered voter of your state. But that's not one of the three qualifications in the U.S. Constitution. And the U.S. Supreme Court has made it very clear that states are not free to add to or modify in any way the basic qualifications that are set out in the U.S. Constitution. Now, for purposes of being a registered voter of Indiana, obviously you have to be a U.S. citizen, you have to be at least 18 years of age, and you have to be a resident of the state. And at least since 1995, residence has been defined in statute as being a true permanent fixed home or establishment that you claim as your residence.
Before we get into that, let's talk about the federal constitutional provision. It requires you to be an inhabitant of the state. How does that differ from being a resident of the state?
Well, it's kind of when you study the case law, there isn't a lot of difference. If you go back and look at the debates when they were trying to decide the wording to include in the U.S. Constitution, but the framers apparently decided to use the term inhabitant as opposed to residence because they thought the term residence was more subject to mischief in terms of that if you're an inhabitant, that was a more definable term that people wouldn't disagree with. Federal court decisions have helped sort of fill in the gaps a little bit, and they indicate that to be an inhabitant of a state within the meaning of the U.S. Constitution, you have to maintain a physical presence within the state, and that has to be coupled with an intent to habitate within a state.
Okay. I'm sorry, Mark. You go ahead.
No, go ahead.
Okay. There's a challenge. There was a challenge for the election commission, which we should distinguish between the county board of election.
Right.
The challenge before the state election commission was whether and dealt with the inhabitancy issue. Correct?
That's correct. A group of citizens timely filed a challenge to Senator Lugar's re-election to the Senate, claiming that he was not an inhabitant of the state because the residence that he had at the time of his first election in 1976 had been abandoned in 1977, and they claimed that he no longer inhabited the state, so he couldn't be eligible to run for office. Now, interestingly, the Indiana Code incorporates the constitutional eligibility requirement for U.S. senators and U.S. House representatives in the Indiana election code.
So just to be clear, that means Indiana Code basically says our requirements for federal office reflects that of the U.S. Constitution.
That is correct.
Okay.
That is correct. And so that was the basis that the citizens brought their challenge, we can get into these attorney general opinions that rely on state constitutional provision, but the election commission really, if you watch the hearing, it was streamed live over the internet, and they never really gave a definitive reason for their ruling, but essentially, you could gather that they were deferring to the U.S. Senate, and but the important point is that the Senator Lugar could always argue that you can't determine whether he's eligible for election to this next term until November, and to the general election. And they were arguing that it should apply to the primary election, you can debate over what the federal court decisions say on that, but the Election Commission basically deferred and said that he's been previously determined to be eligible, and basically we're not going to wade into that if the Senate deems that he's not an inhabitant as of the election. And that was the impression I got from them, that they weren't willing to wade into that on a pre-election challenge.
Is that a matter to be determined by the United States Senate, that if the courts were to interfere would be a violation of checks and balances, or rather the separation of powers of the three branches? If that has to do with a body's self-rule of itself, just like the Supreme Court has its own internal rules, would that be something the courts could not interfere with?
Well, and that is a very interesting point, because clearly states have regularly thrown federal candidates off the ballot because they didn't meet the age requirement, or they weren't citizens. That was a very ascertainable point that you couldn't disagree upon. And so, your age is what it is. Whereas
not necessarily
whether you're an inhabitant or not, that's why I think that the courts in that case probably are reluctant to declare. And the best case of that we had recently was in the Tom DeLay case. Tom DeLay, of course, was the House Majority Leader from Texas. Had served in the U.S. Senate from Texas, or U.S. House of Representatives from Texas since 1984. Got into a lot of ethics problems, and after he won renomination to another term, decided that he didn't want to be a candidate for re-election anymore. But the only way the Texas Republican Party could replace him on the ballot was if he was deemed ineligible to seek re-election. So he effected a change in his voter registration to his Virginia home. He effected a change in his driver's license to his Virginia address. He effected a change to his income tax withholdings to reflect his Virginia address. And on that basis, the Texas Republican Party attempted to declare him ineligible to hold the office and replace him. The Democratic Party challenged it, and this case went up on appeal to the Fifth Circuit Court of Appeals, which essentially said, we can't decide this until the November election.
We're just about done with this first segment, but on age, they could always use a different base than base 10. It could have been base 8. We'll be back in just a minute.